Hello and welcome to this webinar. Really excited to be coming to you live today. We've got a big crowd. People are rushing in at the moment. We had over 300 people who were registered for this webinar, and it's great to see lots of people flooding in. I think we should get started. It is time to start. So today is the first of 5 webinars that we are doing. They're free or complimentary webinars, and really what we wanted to do is to help people work out what they should be doing for POPIA now that we finally have a commencement date. And so over the next 2 weeks, we'll be doing these 5 webinars in which we'll explore different topics. And really, we thought to ourselves, what are the questions that you should be asking yourselves to help you navigate this and work out what your next steps are? And that's what we're going to be taking you through. The first of those questions today, which is, must I comply with the POPIA Act? So my name is John Giles. I'm the managing attorney at Michalsons. We also have David Late with us. He is one of our attorneys and has been focusing specifically, well, one of the things that he does is look at the responsible party and the data processing relationships. And then we also have Nathan Ross Adams, who is also going to be assisting us and particularly helping us with answering questions as we go through the session. So the format of today's session, we're going to be presenting, mainly me with some David coming in at different times. And we're going to present for about half an hour on this question of, must you comply with the POPIA Act? And during that time, we're going to run a variety of polls. So please be on the ball, be ready to answer, because we're going to be quite quick with those polls. But it's going to make today's session very interactive and really enjoyable. And then at the end, so after about 30 minutes, we're then going to have question time. And Nathan Ross is going to try and identify themes relating to the questions, so we can answer as many questions as possible. I'm sure we're going to run out of time. But we can answer questions for as long as you want at the end, but the first half hour or so is going to be the key time. So that's the format for the day. And I think we should kick in. I see we've just passed the 200 mark of people coming in, which is a really nice crowd, which is fantastic. All right, so I'm going to share my screen. And today we're going to be using our normal presentation, which we use for all our presentations. We're going to go into the introduction section, looking at the global view, looking at data protection laws, and we're going to zoom in on the Protection of Personal Information Act and talk a bit about this particular act. And I want to start by saying to everybody, don't panic and keep calm. It's amazing. Lots of people are really stressed about this law. They are really worried, and I just really want to reassure you and say, keep calm. We do have time. Yes, it kicks off tomorrow, but we've got 12 months. And as we've seen in other jurisdictions, regulators are hesitant even after that deadline to start fining people quickly. They normally ease into it. And so there is time. Also, I want to reassure you that really nobody is going to go to jail. It's very, very unlikely that someone will go to jail. And also that you've got this. I've interacted with lots of people who really are skilled and knowledgeable people. And I really believe that we can achieve this over a 12-month period, and we'll be fine. And I think the other reassuring thing is that for most of you, you've already done 80% of what is required from POPIA. And so it's really about just doing that extra 20%. And it's often really nice when people realize that they have done much of it already. And for many of us that are on the call, we also have been doing things like the Gdpr for some time. So many of you have been protecting data, protecting personal information for various reasons, whether it's standards that require it or contracts that require it. And so we really are in a pretty good place, and there is work to do, but it's achievable, and we're here to help, and together we can get through what needs to happen in the next 12 months. All right, so then let's go to the first question of who has to comply with POPIA. The other bubbles that are here are what we'll be covering over the next few webinars. So please register for those webinars if you enjoyed today and you'd like to ask those questions or get answers to those questions. Today, we're very much focusing on this question, and maybe if we can also keep the questions to this topic, there'll be an opportunity to answer other questions on the other topics as we go through the next couple of weeks. So this question sounds a bit crazy, must I comply with the POPIA Act? And many people might think, well, obviously I've got to comply with the POPIA Act. But I think it's not as simple as that, and it's a very important question to ask, because if the answer is no, then it's not your problem, and you don't need to be focusing on it. And so surely it's the first question to ask, is to say, well, do I actually need to comply with this law? And whilst it might seem obvious, there are quite a few really interesting issues that come up as part of it. And that's really what we wanted to tackle today. So before we go any further, what I wanted to do is I want to run a quick poll, which is to ask all of you whether you currently think that you need to comply with the POPIA Act. So the poll should be coming up on your screen now. And if you wouldn't mind answering that poll, that would be great. So the question is, must my organization comply with POPIA Act? Yes, no, or I'm not sure. And let's get an overview. It's great. We've got, more than 160 people have answered already. So you're on the ball and you're listening. Well done. So I'll just give you a few more seconds to respond there. Okay, let's leave it at that. And I'll share the results with you. So overwhelmingly, 91% of you say, yes, you must comply with POPIA. Only 1% says no, and 9% says, I'm not sure. And so we're really hoping that we can resolve the issue for the 9%. And I think it might be interesting that out of the 91%, some of you might realize that you actually don't need to comply, or don't need to comply with aspects of it. So let's see if that 91% changes as we go through this presentation. All right, so let's go back to our presentation. And so the first question to answer, and what we've tried to do is to phrase questions, and if you answer yes, then you must comply. If you answer no, then you don't need to comply, either entirely or for that particular aspect. But the first very important thing to ask is, am I the responsible party? Because this is the way that POPIA is set up, is that it's the responsible party who must comply. So who is this person? And it's really, really important that you know when you are the responsible party and when you're not. And so at this point, I'm going to hand over to David Late. As I said, he's our lead on the module in our program on the role players. And we also have a program specifically on data processing relationships. So David, over to you.
Great. Thanks very much, John. Brilliant. So as John said, very important question when it comes to POPIA compliance. Am I the responsible party? So who is the responsible party? They are the mastermind. They decide why and how to process personal information. And in fact, in that definition, one part's more important than the other. It's far more important that they determine why. So they are determining the overarching reason, the purpose for which the personal information is being processed. They can outsource most of the how and still be the responsible party. So this harks back to this idea that I always put forward, is that no organization is an island. We all process personal information, but we process personal information together with others. So the question is, who does the responsible party process personal information with? Well, they process it with the operator. So the operator is the yes person, the henchman, the minion, who follows the responsible party's instructions without coming under their direct authority. So an important thing to understand is that if you are part of the responsible parties, so like if you're an employee of the organization, you are not then a processor, you'll be part of the responsible party. Processors are typically external organizations, service providers, vendors, and things like that. So we have this distinction between the responsible party and the operator. And you might think that from the sound of it, generally, it's whoever is requesting a service is the responsible party, and whoever's providing the service is the operator. And while that's generally true, and let's think about sort of a classic example of outsourced payroll, right? Most businesses have staff that they pay, and you could do that function yourself, but you might decide that it's easier to hire an external payroll company to provide that service to you. Now, you tell that external payroll company who to pay, how much to pay them, when to pay them. There's very little discretion there. So in that situation, you are the customer, essentially. You are getting the service provider to provide you the service, but you remain the responsible party for how and why they provide that service. Therefore, the buck stops with you when it comes to POPIA. So if anything goes wrong, if there's a breach, for example, or any data subject's rights are infringed, you will be responsible for that. But let's talk about another less common example. Sometimes you're outsourcing a service that you don't understand fully, that you couldn't have done yourself. So the classic example sort of in our day-to-day lives is, let's say you go to a divorce attorney, right? And you want to get divorced, right? Now you present them with all your personal information. You present them with your marriage certificate, your various ID documents and things like that. And they decide why and how to process that personal information to divorce you. And in a company situation, the activity might be something like getting a merger or an audit done on your business. An audit's a great example. So you go to external auditors and you say, audit my business, right? So even though you're paying them to provide you with the service, now it flips. Now they're not the responsible. Now you're not the responsible party. Rather, they are the responsible party because they have external rules and requirements fettering their discretion. So in that scenario, you then become the operator when you're working with them. That's a far less common situation. The third option, which occurs most rarely, is what we call joint responsible parties or co-responsible parties. We are working together to process the personal data. And an example there might, let's say you're working with the same payroll company, but you're doing something like providing a loyalty program to your employees where you will run the front end and they'll run the back end. In that situation, you could be co-responsible parties. So it can get quite confusing. Important headline to remember is that generally, if you are instructing someone to provide you a service, you are the responsible party and they are a processor. But, sorry, an operator. Processes international language, but in South Africa, we talk about an operator. But that onus can flip depending on who you're instructing and what you're instructing them to do. And the reason this distinction matters is the responsible party has the lion's share of responsibility for complying with POPIA. There are a few things that the operator has to do. The two main things are secure the personal data against unauthorized access and follow the responsible party's instructions. So in a nutshell, that is how you determine who's the responsible party. Back to you, John.
Thanks, David. That's great. So now I want to launch another poll here. And so this poll is, what role do you normally perform? And let's get an idea of what the audience normally does. And I think while you're answering that poll, what we've often seen is that an operator gets dragged into helping their responsible party comply, or the responsible party tries to pass on all the obligations to an operator, which is not really correct. You know, the responsible party is responsible for complying, not the operator. And so this is absolutely crucial. You must know when you are the responsible party, when you are the operator in the context of certain activities, and then be very clear on that role and know what that means for you. Because as David said, if you're the operator, your obligation of what you've got to do is much, much less than if you're the responsible party. Great, so the votes are coming in thick and fast. Let's end that and share the results. All right, so we've got 35% are controllers, 25 are processors, lots of joint controllers as well, or responsible parties, and then quite a few who are not sure. Okay, let's move on from there. All right, so the next key question that we're going to look at is, well, what types of responsible parties or what types of parties are there? And I thought I'd be clever here and give you an image of the other kind of party, which is the one that's a lot more fun. We're not talking about those kinds of parties, we're talking about responsible parties. But essentially, a responsible party could be a public body like a government department, a municipality. And what we've also noticed is that, generally speaking, public bodies don't realize that they need to comply with POPIA. I think it's because they were exempt from the Consumer Protection Act, but all public bodies need to comply with POPIA. Then you've got private bodies like partnerships, and then you've got natural persons who carry on or has carried on any trade or business or profession, but only in that capacity. And this is a really important thing, is that a natural person, so a sole proprietor, for example, can also be the responsible party, but only in that capacity. POPIA doesn't apply to individuals in their personal capacity. We'll see that from another example. And then your responsible parties can be juristic persons. So companies, trusts, and all the rest also need to comply. So again, let's launch a quick poll here. I said there were going to be lots of polls. Let's get an idea of what type of party you are. And again, let's do this quickly. So if you can quickly vote there, let's have a gauge. I'm expecting there not to be many public bodies, but maybe I'll be wrong. Yeah, so we've got some great votes coming in there. If we can keep that going. I'll share the results with you shortly, but yeah, as I suspected, we've got very few public bodies with us today. Thanks, I'll end it there and share the results with you. And so we've only got 6% of public bodies. Most are private bodies. We've got a few natural people who carry on businesses. We've got very few natural persons in their personal capacity, which is great, but that 3% you can actually leave because you don't need to comply with POPIA. POPIA does not apply to natural people in their personal capacity. So you're excused, you can go. And then we've got 23% juristic persons. Okay, that's interesting and great to see. All right, so then let's go to the next question. And this is really the meat of it. And this is where things get really interesting. POPIA essentially says there are two key questions, and it's an or scenario. So if you do either one of these two things, then you have to comply with POPIA. So the first question is, are we domiciled in South Africa? And so domiciled is a Latin word, but it essentially means, do you reside or are you based in South Africa? And so the questions are, do you reside here? Are you based in South Africa? If you're a legal entity, are you registered in South Africa? Are you a natural person living in South Africa? And if you answer yes to any of those questions, then you need to comply with POPIA. This is the equivalent in the EU of the GDPR. The question there is, are we established in the Union? It's very similar considerations, and I think we'll probably borrow from the GDPR here. And in the GDPR, the question really is, do we have the effective and real exercise of activity through stable arrangements in the territory? And that might help you in working out this answer. But for many of you, it's going to be a simple answer of, well, we registered in South Africa, we have to then comply. The second question is, do we process personal information in South Africa? And so do you use equipment like a server or a computer located in South Africa to process personal information? If you answer yes, then you need to comply. But interestingly here, the law has an exception, which is that if you are using a server or equipment in South Africa to simply forward personal data through or on, then you are not processing personal information in South Africa, and you therefore don't need to comply. So this is a really interesting part, because the question is, well, do you process personal information in South Africa? What does that really mean? What is we getting at there? And remember that processing is really broadly defined. So it's if you do anything with data, you're processing it. But when are you processing in South Africa? And I think that this is going to become a key issue that many people are going to grapple with. And I'm sure there will be rulings by the regulator. And in time, there'll probably be case law, because it's a crucial question as to whether or not you need to comply with POPIA. The other question is, do I have an operator who processes personal information on my behalf in South Africa? So in other words, you might be a company registered in the Netherlands, you might process in the Netherlands, but then you appoint an operator in South Africa to process for you, that would then trigger you having to comply with POPIA. So that's a very, very important point. Again, in the EU, they've got similar questions that they've asked here in the past. And yeah, you know, the questions come up is that if you're a South African company, you're only processing the personal data of South African data subjects, but you use Microsoft Azure or 365, and that's based in Ireland. Does that then trigger GDPR compliance? It's a very similar question that we're going to have in South Africa. And in Europe, really, the answer is that it doesn't necessarily trigger GDPR compliance. But in South Africa, I think it will. If you appoint any processor in South Africa, it does mean it'll trigger that you then need to comply with POPIA. So the two key questions, and I want to go through a few examples, but before I do that, I want to launch another poll, which would be, I want to find out, based on who's here on the call, whether you are in South Africa. So if you wouldn't mind ticking there, so are you domiciled in South Africa? Do you process information in South Africa? Both or neither? Now, if you're ticking both, you obviously need to comply. If you tick neither, you don't need to comply. If you tick one of the first two, then that means that you need to comply. And so based on this, the vast majority, well, all of you have to comply with POPIA, which is interesting. I'm surprised that, yeah, I mean, that's pretty much everyone. So there's no one really on the call that doesn't need to comply from this perspective. You're all in South Africa. Very interesting result. So let me share that with you quickly. Yeah, so all of you need to comply. From this perspective, remember though that it's a little bit different, the responsible party aspect, but from this perspective, then you do. So let's look at a few examples here, which is quite interesting. So if you're domiciled in South Africa, but all your data subjects are in India, every single one, you don't have a single South African data subject, and you process the data in South Africa, then you would need to comply with South Africa, even though you don't have a single South African data subject. And that's quite radical. Then let's look, you've got a company, let's say they're in the Netherlands, they're registered there and they process there, but all their data subjects are South Africans. They don't need to comply with POPIA. I mean, isn't that bizarre? And so what this shows you is that POPIA is different from the GDPR. The GDPR applies extraterritorially. In other words, if you're in South Africa, you're not in the EU at all, but you process people's information, personal data that are in the EU, then you need to comply with the GDPR. And that's not how POPIA works. So we really, as South Africa, have let a lot of people off the hook around the world in that they can be outside of South Africa, process outside of South Africa, target South Africans, but don't need to comply with POPIA, which is really quite a bizarre situation. So I know how some of your minds work, and I'm sure there's some of you thinking, oh, well, here's an opportunity, let me move to Mauritius, because I can then be registered in Mauritius, I can process in Mauritius, and I can process personal data of South Africans, but I don't need to comply with POPIA. And that's correct. That's true. And for this reason, I do think that some people will choose to leave South Africa, some responsible parties. The only catch here is that if you move to another country, like if you move to Mauritius, you then have to comply with their data protection law because you registered there, and their law is basically the GDPR, which means you're then going to have to comply with the GDPR. So you might escape POPIA, but you then fall into the net of having to comply with another data protection law. We can maybe come back to more examples at the end in terms of questions. We can look at as many examples as you want and discuss in a bit more detail there as well. All right, so the next issue is that you might not have to comply with the GDPR. And let's say you're an operator, you purely are an operator, which means there's very little for you to do, but you may then have agreed with somebody that you will comply. And there are multiple people who you might agree with. But the key being, if you are an operator for a responsible party, the law requires there to be a data processing agreement between the two of you. And that agreement is going to pass a lot of obligations onto you and require you to comply. You might also be a sub-operator for an operator. So you've got the responsible party, an operator and a sub-operator. And in that scenario, you would have to agree with your operator that you need to comply. You might also share a lot of personal data with somebody in South Africa. And so you're two responsible parties sharing data with each other. The other responsible party who has to comply with POPIA is going to be very reluctant to share personal data with you if you don't comply with POPIA. And so often in those scenarios, there's an agreement that you will comply. And sometimes also your major shareholder requires it, or your major customer requires it. And so often you might not need to, the law doesn't require you to comply, but you have to then agree with somebody that you will comply. And so you don't escape it that way. Unfortunately. Let's just have a quick look here. I just want to see if I've got a poll that relates to this. Yeah, so let's quickly launch this poll. So let's see, has your organization agreed that it will comply? Sure, you're being very responsive. I'm amazed at how quickly the votes are coming in. Yeah, so well done, you're paying attention. Great, so that's not everyone, but let's end it there and let's share the results. So many of you have agreed that you will comply. And some have said no, and some don't know. All right, let's then go to the next key issue, which is looking at, well, okay, so some people are actually exempt from complying with POPIA. And so again, I've turned these into questions. So if you answer yes to any of these questions, then you are exempt and you don't need to comply. So do we process personal information that is not entered into a record? So strangely, if you've got information in a mess, then you don't need to comply with POPIA. It's got to be in a record, which is quite a strange one. The next one is around purely household activities. So if you are just doing it for household activities, then you don't need to comply. This ties in with what we were saying, is that it's only for natural people who are running a business, essentially. That's when they need to comply. If you're a natural person doing it purely for personal or household activities, you don't need to comply. And then the next one is, have we de-identified the information? And if you have, then you're essentially exempt. It's no longer personal data and you don't need to comply with that. If you're a public body that protects national security, you're exempt. If you are a public body that prosecutes offenders, if you, well, very few of you will be, but if you're the cabinet or the executive council of a province, you're also exempt. And then, yeah, if you're essentially performing judicial functions like courts, you're also exempt. And then we also have an exemption for purely journalistic, artistic, or literary purposes. And there you can also be exempt in that scenario. So again, let's run a quick poll to see if anyone is exempt. So if you wouldn't mind voting there, I'm expecting it to be the vast majority to be no. But we do have a few people who are exempt, which is fantastic. You can also leave and you don't have to go any further. If you're exempt, you're obviously, that's it. Nothing more for you to do. So let's just let a few more people vote and I'll share those results with you as well. Yep, so we've got 5% who are exempt, we've got 85% who are not, and some who don't know. If you don't know, we can maybe tackle that in the question section and try and answer those for you in that part of the presentation. So the last thing I wanted to chat about is to talk about, well, so what? What does this mean for us? What are the consequences? And that, for me, they're quite startling. And the first is that one option is to leave South Africa. POPIA actually is encouraging you to leave, because if you're not domiciled in South Africa and you're not processing in South Africa, you don't need to comply with it. So obviously it's a massive step. I can't see many people upping and leaving in a hurry, but it is an option. The other key implication is that you shouldn't outsource data processing to South Africa, particularly if you're domiciled outside of South Africa and you're currently processing outside of South Africa. And so I think the South African Parliament has really shot ourselves in the foot here, because we're not going to attract data processing related work where others in the world want to outsource or offshore it to South Africa, because as soon as somebody does that, they're going to trigger having to comply with POPIA. And that's serious for the outsourced call centers that are in South Africa, the hosting services providers, the direct marketers, the data analytics industry. There are many industries that really are going to want to be getting work from the rest of the world, and this is going to be a hurdle in their way. The other implication is that South African data subjects are not protected, because you can have somebody sitting in India, registered in India, processing in India, targeting South Africans, and they don't need to comply with POPIA. So what protection do South African data subjects have? And for me, this is actually the one that I'm most concerned about and most worried about, and I think is something that we really need to address. So the next question we grappled with, and David and I have discussed this, and I'm going to hand over to David again to give some thoughts, is that for some of you, you don't have to comply. There are not many of you, but if you don't have to comply with POPIA, the question is, well, should you? Isn't it the right thing to do anyway? And so over to you, David.
Great, thanks very much, John. Yeah, I think there's always this tendency to focus on the stick, not the carrot. So, do I have to comply? Whereas sometimes the question might be, well, what are the benefits of me complying? And I'd like to sort of begin with this idea of, just because you don't believe in data protection law doesn't mean it doesn't believe in you. And that's really a case of data protection law, whether it's POPIA or GDPR, is the law of our times. And if you're ignoring it, doesn't mean your customers aren't, doesn't mean your suppliers aren't. So even though you may not have to comply with it, people may raise an eyebrow if it's something that you're not doing. It's also something that all the leading businesses in the world are looking at the moment. If you go to all the big JSE listed companies in South Africa, you'll find they're talking about it on their website. Internationally, all the big tech companies are talking about it. So it makes you look like a much bigger business if you're focusing on POPIA and data protection when your competitors are not. Then, as John mentioned, you might want to leave South Africa to get away from it. As soon as you get out of South Africa, well, now it's the devil you don't know. You now have to comply with data protection laws that you're not familiar with in other jurisdictions. Data protection laws everywhere. Even holdouts like the US now have the California Consumer Privacy Act. It's ending up being everywhere. And then if your goal is to go global, you're currently a local South African business, but you want to get customers overseas, well, the EU is South Africa's biggest trading partner. And there you have to comply with GDPR. And because there's an 80% overlap between POPIA and GDPR, you're so much more on your way to being able to comply with that law if you already comply with POPIA. And it's never going to be wasted efforts. European data protection laws, South African data protection laws, they all have the same DNA. They're based on the same European directives from the 1990s, the same treaties from the 1980s. And even if POPIA doesn't apply to you, GDPR, well, may. So you could ignore it if you like, but it's probably not going to be to your advantage. But also there's so much to gain from it at the end of the day. And I think let's focus on what you can win by complying with POPIA, not what you'll lose by not complying with it. Thanks, John.
Great, thanks, David. Yeah, so that really wraps up what we were going to be presenting today. I think what we're going to be tackling over the next sessions is we're going to do the next one on Thursday. We're doing an overview of POPIA, again, in literally 30 minutes. So it'll be the very high level overview, but will give you a much better level of awareness. Then we're going to be looking at, well, who's the right person to be driving this? And we want to try and help you to make sure that you're clear that you do want to take this on, or whether somebody else should be taking it on. And then we'll be looking at the impact. So what is the impact on your specific organization? And in that webinar, we're doing really a group privacy impact assessment on everybody, but we'll walk through the factors and considerations so that you know what the impact is on your organization. And then the last webinar, we will be looking at what's next and what are the steps, how we can help you, and what you should be thinking about. So I think, you know, what we've got to here, and let's launch another quick poll to round this off. Let's go to polling, and I want to ask the same question now as, must my organization comply with the POPI Act? So this is exactly the same question we had at the beginning, and let's see if the percentages are any different. And I'm really hoping here that we don't have any, I'm still not sure. I'm hoping that we've changed it a bit. I'll just give you a few more seconds to that. So please also ask your questions. We'll switch shortly. We're going to start with the questions. So while we're also waiting for this, you can join the webinars that are happening over the next 2 weeks, but if you're also sure already about, you've got a high level of awareness, you know URIT, and you know the impact on your organization, you can go straight to the next steps. And essentially, we can help you by, you can either join one of our programs, our data protection programs. There's one for large, medium, and small organizations, and we've got a POPI lens, which helps you to look at it through the perspective of POPI. Or we're here to help you. We can comply for you is the other option. And so please inquire, contact us and ask us for a quote, and we can then scope and identify how we can do something for you. You can do that using support@michalsons.com is the email address. And the other thought, if you're also wanting to jump ahead, is that you can do an individual privacy impact assessment for your particular organization. That's also complimentary. It takes about half an hour, and we're doing lots and lots of them at the moment. But if you're wanting to get the impact on your organization, then that's a great thing to be doing. So if we share these results, sure, so we're at 93%, we were at 91%, but I'm pleased that we've got less, I think, of the I'm not sure's. But I am surprised that we've gone up. So more people think that they have to comply than what we had. Maybe the people who don't need to comply have left already, so they're not entering the poll. But that is an interesting stat to look at. All right, so should we go to some questions? And maybe, Nathan, have you been able to identify any key themes in terms of the questions?
Hi, John and David. Yes, there seems to be certain categories of questions relating to the responsible party, what constitutes processing of personal information, as well as proving compliance with POPIA. I'm going to run through some general theme questions, and then perhaps you and David can interchangeably answer them. So one of the first questions is, will responsible parties have to register with the information regulator?
I can take that question. So responsible parties don't. There are only a few who require prior authorization. And it's one of the key things to check. At a point in time, the regulator will launch functionality on their website, I'm sure, that will enable you to obtain that prior authorization. Although it's really, you're getting authorization from the law, not really from the regulator. So the responsible party doesn't need to register, but the information officer needs to be registered with the regulator. And hopefully the regulator creates a nice web-based form where you're able to register your information officer easily.
Thanks. The next question for David would be, what are co-responsible parties?
So co-responsible parties are a situation where they're both determining the why and how to some extent. It's the least common of the three. The practical example there is typically where there's two businesses that each could have done the functionality themselves, and they've sort of partnered together to provide it as a unit. there, the most important thing is, if we think about data protection as a bundle of principles or conditions in the case of POPIA, you need to divide up the conditions between the parties in a way that makes sense. So for example, the one co-responsible party might deal with the front end stuff, actually collecting the data from or the personal information from the data subjects, whereas the other party might deal with the back end stuff, actually storing it or processing it. So let's say, for example, you had a loyalty program for your employees, and you as the employer were working with the employees to collect the information as to whether they wanted to be part of that program, whereas the program provider in the back end then is actually providing that program. That could just as easily be a controller-processor relationship, but it comes down to the subtleties of how that is regulated in terms of the contracts.
Thanks, David. One of the very interesting questions that links the responsible party to general business processing activities and operations is whether the responsible party now needs to have a more active role in meeting with operations departments and mapping out each processing activity. Is that necessary?
I'll speak to that one there. So absolutely, the responsible party now has to do a lot more with the operator to make sure that they're checking what they're doing. And we're seeing this trend happening internationally. If you look at big tech companies, the likes of Microsoft and things like that, they have very comprehensive data protection programs where they look to all their suppliers and make sure that they are doing the necessary things. And in fact, they actually get them audited by independent assessors sometimes to check that they're doing what they are supposed to be doing. That is overkill for many organizations, but at the very least, you're going to need to have warranties and indemnities rather in your data processing agreements, so that if your operator does something that they're not supposed to do, you as a responsible party have some leverage over them. Great.
Yeah, what I've just been doing while you're talking is I'm sharing my screen and looking at our website for related material. And this is a page where we talk about the responsible party's obligation to create a record of their processing activities. And that is something that needs to happen. And part of creating that record of processing activities is identifying when you are the responsible party. And we can't tackle that in detail now. And I also showed you the page before this was going into some detail on our website about how to identify when you are the responsible party or a joint responsible party. But it's such an important step. And for me, it's one of the key insights. So many people jump past it. And you have to know, when are you holding the hot potato? When are you the responsible party? And when do you have to comply? You have to do this step. It's such an important one.
Okay, thanks. And then linked to the data processing, one of the participants had a question of whether their NDAs covers data protection.
So I'll tackle that one. NDAs are about confidential information. They're not about personal information. Sometimes personal information or confidential information includes personal information, but they're really separate things. And so NDAs can be useful, but they're really a related thing. They're not going to help in a huge amount or a huge way.
Okay, thanks, John. Our next question deals with whether, if a company is compliant with POPIA, are they compliant with POPIA as well?
I can tackle that. Yeah, so POPIA is the Promotion of Access to Information Act. It's our South Africa's Freedom of Information Law, versus POPIA is the data protection law. So they're almost opposites. They're two sides of the same coin. And so no, definitely not. They're separate issues, and you'll need to tackle both of them. I think where there's a bit of confusion there is that POPIA requires some organizations, and I stress only some, not all, only some need to have a POPIA manual. And then a POPIA says that you need to put certain things in that POPIA manual, but actually those need to be in a privacy policy and not in your POPIA manual. And that's an important thing to do. So no, they're separate issues and need to deal with both of them. And we're expecting POPIA to become a much bigger deal, because in future, not tomorrow, but in the future, POPIA will also be regulated by the information regulator.
Okay, thanks, John. One of the next questions deals with the processing of personal information, and the panel participants wanted to know whether they are responsible for the personal information that their suppliers process as well.
I mean, I'll take, sorry, go for it, John.
No, go for it.
Yeah, I was just going to say it depends on whether that supplier is considered an operator or not. And, you know, once again, that goes down to your responsible party assessment there. But in terms of the default of 80% of the time, if you are the one requisitioning a service, then you are the responsible party, and you're the one providing a service, then you're an operator. Then generally, yes, you would be responsible for how your suppliers are processing personal data. But it depends. Sometimes the supplier is the responsible party and not the operator. So it's not based on whether they're a supplier or not.
Thanks for that, David. The next theme of questions focuses on personal data itself and what constitutes personal data. One of the participants would rather want to know whether encryption, or rather encryption, is a form of de-identifying personal data.
David, I think over to you.
Sure, yeah. So I specialize in information security when it comes to data protection as well. And I think it's a mistake to conflate encryption with de-identification. So de-identification, in terms of the definition in POPIA, is taking personal information and putting it in such a state that it cannot be re-identified. Encryption is obfuscating it from unauthorized access, which are very different things. So if you've encrypted data, it remains personal information, but encryption might be relevant in other circumstances. So for example, if you have a data breach, it's arguable that if data is sufficiently encrypted, it's unlikely that someone would have been able to get access to that personal data and therefore infringe the rights of data subjects. And it might be relevant in that circumstance, but it doesn't mean that you can process, it doesn't mean that data protection law doesn't apply to it as it does the de-identified data. So that's a very dangerous mistake to conflate those two. But yeah, good question, thanks.
I think
Go ahead, John.
Just add, you know, personal data is essentially any information that identifies a person. And that's what you want to focus on. It's, can you, with this data, identify a person? And so there's some interesting aspects to that which we don't have time for. Maybe quickly just to show you this slide, which is looking at data classification. And this is another really important point, is that POPI or POPIA only applies to personal information, not other kinds of information. And so another really important question is to work out, well, what personal information do I have? And what is personal information? So I'm glad you're asking the question. It is a very important one.
And the next question relates to the information officer, and specifically, one of the participants would like to know who shouldn't be the information officer, who shouldn't be appointed as the information officer.
So we're really going to tackle this not on Thursday, but Tuesday next week, where we look at, well, okay, now your organization has to comply. Who is the right person to drive it? And POPIA says that it's your information officer is the person who needs to drive it. They are responsible for ensuring compliance. And you're right, the question then is, well, who's the right person in my organization? We'll go into more detail on this next Tuesday, because it's quite a tricky question. It's not a one size fits all. It depends on a number of factors, and it's specific to organizations. So, but many organizations, it's legal and compliance. Sometimes it's the company secretary. It can be data governance. It can be somebody in risk, sometimes somebody in finance. But the key is that they must be involved, and they are going to have to perform quite a significant role over the next 12 months. So I think I'll leave it there, and we'll tackle that on Tuesday next week.
Okay, perfect. Thanks, John. And then the last set of questions are sort of linked to compliance or other non-compliance with POPIA. Specifically, the participants would like to know how they would be able to check whether someone is compliant with POPIA or not. Is there a sort of certificate that verifies that someone is POPIA compliant? And then the second leg of that question is, what are the consequences for not being compliant?
Okay, great. So I'll tackle that. I think very quickly here, we can look at what the risks are of non-compliance. And they range from losing customers and reputational damage, which for me is the biggest for almost everybody. There is a possibility of getting fined up to 10 million Rand. There's a possibility of jail, but that's very low. There's also a possibility of having to pay damages for loss that data subjects have suffered, which I also think is possible, but we'll have to see how that develops over time. So those are some of the consequences. I agree with David. I like looking at the carrot rather than the stick. I think the carrot is that you're building trust with your customers, your data subjects, your employees. You're protecting them from harm. You are being a good citizen, and that will translate into more business, happy employees, and happy stakeholders, and it will impact the bottom line. And then the other question was around certification. And again, it's a little bit out of the scope of today, but we tackle that. We've got, again, a whole module in our program talking about audits and certification. The one key point here is that at the moment, it is not possible to be POPIA certified. There just isn't anyone who does it. And it's a whole process. We've seen this in the GDPR, that it's not possible to be GDPR certified. And they are, it's almost 4 years since their commencement. So it's going to be some time before in South Africa it's possible to get POPIA certified. It's much easier to get certified against a particular thing. So against the ISO 27701 standard or against the Bureau Veritas standard. But getting POPIA certified does not exist, and I can't see that happening for some time.
Thanks, John and David. That seems to be all of the questions that have come through. Thank you very much for answering them.
It's a pleasure. Great. And that's pretty good timing. Are there any more questions or any more thoughts? It's been a great session. I must say I've enjoyed it very much. Thank you for your interactions. I can see here in the chat box there's been lots of interactions. And it's also nice to get some really nice feedback. So thank you very much. It's a pleasure. I'm glad that you found it useful. Yeah, so if you enjoyed today, then register for Thursday's session. Again, it's at 11 o'clock. And we're going to be doing an overview of POPIA in that session. And then also register for the others. And obviously on our website is a huge amount of information. And you can check out there in a lot more detail about how we can help you. You can find out more about our programs. You can find out more about what we can do for you. And also feel free to ask us questions. You can mail questions that haven't been answered to support@michalsons.co.za, and we'll try to get to as many as possible then. All right, if there's nothing else to mention, any other late questions, Nathan, or shall we call it there?
We can call it there. Most of the questions have been answered collectively according to their themes. Thanks, John and David.
Perfect. Thanks very much, David, and thank you for attending. And we enjoy the rest of your day.